Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present here. Brad Brewer. All right, so in cause number CR 23-6, State of Texas versus Brad Andrew Burr. It's a sanctions court hearing. So Mr. Burr is in inpatient Texas Recovery Center. We set that to June 2nd for status. Joshua Brown. Bryce Carroll. I saw Mr. Carroll outside. So Kirkland Huggins. Patrick Rowe. Sanctions court hearing CR 23-117. Mr. Rowe is reset for sanctions court May 12th. Requested by Ms. Clark. Matthew Scott Williams, CR 25-239. Was confirmed in custody in Ouachita Parish yesterday, I believe. So we'll recall that case. Said it. Paula Faye Ackridge Mora. On the screen. She's here. Be ready. Okay. Tammy Diane Crocker. Cody Allen Gray. Mr. Gray is going to be appearing via Zoom today, indicating to the court that there was a car accident. He had surgery last week. So the court has granted Mr. Gray the ability to appear via Zoom for a probation extension. Dennis Ray Jones. Guy McPaden. Joshua Morgan. Here. Wayne Wingo. Martavius Wilson. Andrea Young. CR 22-121. Ms. Young's case has been continued to May 12th. Ms. Young was ordered to appear to sign a notice of appearance and to be drug tested by the pretrial release officer. Wesley Ball. Here. Michael Ringle. Jeffrey Smith. Jeffrey Allen Smith. Mr. White, thank you. Appreciate it. Jeffrey Chen is set at 9:30. And Mr. Chen is here. Thank you, Mr. Chen. All right, we have any counsel that's ready?
There's Mr. Gray on Zoom.
No, sir.
Okay. So it's not ready.
Jurors are contested hearing today.
Subject to your.
Let's go ahead and bring your client up. CR 25-243, State of Texas versus Paula Faye Ackridge Mora. We're set on the motion to suppress. Go ahead, Mr. Green.
That's right, Judge. And the state of Texas, through Mr. Hartwell, has filed a motion requesting more specificity in my motion to suppress. And we visited with that. I don't want to get that to him. We just asked that it be reset for another contested hearing.
No objection, Your Honor.
Okay. All right, court will set Ms. Ackridge Mora. Court at the docket May 28th. So the motion needs to be heard on that day or it's going to be denied.
Understood, Judge.
And once she signs her appearance, she's free to go. The other council is ready? Mr. Huggins? All right, this is cause number CR 20-125, sanctions court hearing. Kirkland Wade Huggins. All right, Mr. Huggins, it looks like you have complied with all of your previous orders regarding payment to your probation fees, payment to your court collections, 20 hours community service, and your attending counseling. So everything looks really good.
Yes, sir.
Good. How's your hand recovering? How are you doing?
I just actually got the pins pulled out of it last week, and I'm actually starting to be able to get a little bit of movement in my finger again.
Good for you. Sure you're ready to have that thing off and have your hand back.
Yeah, I'm ready to go back to work. My parents we were blessed enough to help me out, and I'm thankful for them with the probation. And since I was sitting at home, I can at least pick up trash one-handed.
That's right. That's right. That's the right attitude to have, and you have to be grateful for your parents and their help and everyone else that's helping you.
Yes,
All
sir.
right, so what I'll do, Mr. Huggins, is I'm gonna have you come back on June 2nd. We'll do the same things, okay? $130 to probation, $80 to court collections, 20 hours community service, and continue your counseling, okay?
Yes, sir.
We're gonna bring this notice of appearance to you, have you sign that. Free to
Sir, thank you very much.
keep up the good work.
Yes, sir. Thank you.
Carroll. It's a sanctions court hearing, cause number CR 21-208. Bryce Christopher Carroll. Mr. Carroll, have you paid your court collection today or yesterday?
So,
Are you gonna be able to pay it today?
not today.
When can you pay it?
Friday.
Friday? All right, court finds that you have complied with your probation sanction to pay probation fees, that you did your 20 hours community service. I'll give you the extension till Friday of this week to pay for, that's gonna be for April. So what I'm gonna order for May, it's gonna be due before you come back in June, all right? So I'm gonna have you come back on June 2nd, and we're gonna do $60 to probation, 300 to court collections, and it says, oh, you're down to 14 hours of community service. That's it. That's it. That's to complete it. All right. So that might be the best 13 hours you worked.
Yeah.
Yeah. Right. So, and then just to make sure you get that paid, your 300 for April, and then bring your 300 for May before June 2nd. Okay. All right. And I probation y'all want to see. Okay. I'm gonna have you sign your notes of appearance, then come over here and see Ms. Burns. accept.
Good. Yes. Um, yeah, I know Stephanie's behind. She's still looking at stuff. Maybe it's that. Hey, Nolan.
Director clause number CR 25-239, State of Texas versus Matthew Scott Williams. Mr. Williams is set for arraignment today on evading arrest or detention of the vehicle. Third degree felony. Mr. Williams is verified in custody in Washita Parish, Louisiana. Court will reset this case again for status of custody. We'll reset this to June 30th. Three.
Good morning, Your Honor.
Morning, Ms. Shaw. Give me just one moment. I'm gonna get you set up, okay?
I'm sorry, I'm in Uber, so it'll be a little bit different because I thought I would get there earlier, but here I am.
How much time do you need before you get where you
Maybe
need?
10 more minutes, I'll be arriving at the venue. Then I can go ahead and start in
That's
a
fine.
quieter position, if
Yeah,
you don't
that's-
mind.
Yeah, that's fine. Just go ahead and exit out and then just log back.
Okay,
Get
I'll
there.
come back then. Thank you so much for your patience, Your Honor.
You're
Bye-bye.
welcome. Not a problem.
Bye.
Mr. Platt. Who would you like to call?
Can we call Mr. Brown?
Joshua Neil Brown, CR 24-255. One of us. This is a hearing on the state's motion to adjudicate. Any announcements, Mr. White?
State doesn't object. I just, was retained on this. We could have it reset.
Any objections from state? Mr. Hernandez, any other questions? All right, we'll reset Mr. Brown to May 28th at 9 a.m. Brown, just remember, you're still on community supervision, still have to comply with all the orders of work, gotta report, gotta pay, gotta drug test, gotta do all those things, okay?
Yes, sir.
If you don't, then the state can amend their motion to allege new violations. Makes Mr. White's job even harder.
Yes, sir.
Okay, all right. Ready to go. Anyone else, Mr. White?
Mr. Ringo,
Mr. Ringold. This is cause number CR 20-356, State versus Michael Thomas Ringold on state's motion to adjudicate.
the state's got it.
Yes, sir, please. All right, Mr. Ringold, the state has filed its motion to withdraw the state's motion to adjudicate. The court is granting that this day. If you want a copy of this for your records, if you will stay out in the hallway, we'll bring it to you. Otherwise, you're free to go. Anyone else, Mr. White?
Mr. Smith,
Jeffrey Allen Smith. It's called number CR 24-176 on state's motion to adjudicate. Yes. Mr. Smith? We're back on record. Cause number CR 24-176, State versus Jeffrey Allen Smith. Court is going to reset today's hearing on the motion to adjudicate to May 28th. Party's request, that'll be at 9 a.m. Once he signs his appearance, Mr. White, he is free to go.
I'm gonna step back out.
Yes, thank you, Mr. White. Mr. Platt, go ahead and give. Yes, please.
Good morning again, Your Honor.
Good morning. Give me just one moment. I'm going to get you set up here.
Sure, thank you.
Should see the interpretation. Turn your video on.
Can you get her to test it?
Second, there's something not right because you're getting the sound.
Yeah, the windows can hear me okay.
Okay, thank you. Just one moment. We have to make an adjustment. Have him say something.
Copy that, thank you.
You say something. Say
Can you have Mr. Chen say his name?
Hello?
So.
OK 好。是
Yeah, Mr. Platt, do me a favor, your microphone right there, that green one, just move it between you and Mr. Chen. That's the way she's gonna get come up. Perfect, yes, sir. All right, let's try it now. Court is now on record in cause number CR 24-00013, State of Texas versus Jeffrey Chen. Court finds that Mr. Chen needs the assistance of a language interpreter. The court is going to swear in Ms. Ida Shaw at this time. Ms. Shaw, if you'll raise your hand, I'm going to place you under oath. Do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness now on trial to the best of your skill and judgment, so help you God? All right, thank you. And can you go ahead and state your name and license number? And can you ask Mr. Chen if he's hearing you?
听得见。
Excellent. Okay, we'll begin the hearing. All right, Mr. Chen has been charged with a first-degree felony offense of money laundering in an amount greater than $300,000, which is a first-degree felony that does carry a range of punishment of not less than 5 years or more than 99 years or life confinement in prison if he were to be convicted and sentenced. Today, we are set for arraignment. Mr. Platten, have you had an opportunity to go over the indictment with your client?
Yes, Your Honor.
All right, and does he waive the formal requirements of arraignment, or does he want that read by the state?
He waives the reading
And how does he enter a plea?
of not guilty.
All right, court will find that Mr. Chen has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record. Court now sets this matter for pretrial hearing. Mr. Platten, if you have your calendar with you, look at setting either, there's 3 dates available in June 2nd, 4th, or 16th. 2nd, 4th, or 16th.
Could it be a little later that morning?
Yes, we can do it, like 10 o'clock.
To 11? And, yeah, I think I can work.
10 o'clock.
Yes, Judge.
Which date? 2, 4, or 16? 4.
Yes.
All right, court sets Mr. Chen then for pretrial hearing June 4th at 10 a.m. And Mr. Chen, do you have any questions about the court's pretrial release conditions that you discussed at our last setting with the pretrial release officer, Mr. West? Do you have any questions about those? All right, thank you. All right, Mr. Chen, we'll see you back on June 4th at 10 a.m.
I know there's a factor of distance here, Your Honor. And I didn't know, since he's in New York, if some of this could be done by Zoom. He was here last Thursday, and of course I was stuck in Tyler. I didn't know if that could be a possibility for some of this.
Court would consider it if there's a need for it. So I'm going to wait, let you and the state discuss the case to determine if there's any pretrial issues. If the state doesn't oppose and there's no objection by the pretrial release officer, we'll have to maintain his compliance. So if pretrial release says it's okay, state says they have no objections, then court would definitely consider it.
Thank you, Your Honor.
You're welcome. All right, if there's nothing further, Mr. Chen, you're free to go.
Thank you, Judge.
Yes, thank you, Ms. Shaw. I do appreciate you.
Thank you.
You're welcome. You have a good day. Mr. Manning, do you have any announcements, just announcements on class? Who would you like to call first? Ms. Crocker, this is cause number CR 05-63, State of Texas versus Tammy Diane Crocker on state's motion to adjudicate, I believe we're in restitution compliance.
Yes, Judge. As of April 14th, Ms. Crocker made a $200 payment, and then on April 28th, she made a $50 payment. Judge, the reasons for the differences there is she was sick and unable to work, but she has since the beginning of April made $250 payment towards her restitution.
Very well. How long of a reset are you asking for, Mr. Manning?
Judge, if we can have a little bit longer, she has shown the past two settings, she has been able to make significant progress in paying towards that restitution. And so we'd ask for maybe just a little bit longer setting. She's continuing to do what she needs to.
Any objections to June 30th?
No objection, Your Honor.
All right, court will set Ms. Crocker for compliance status on her restitution, June 30th at 9 a.m.
Thank you, Judge.
She signed.
Thank you.
Thank you, Judge.
Welcome.
Judge, do we have Mr. Gray?
No.
Okay. Mr. Gray contacted our office while I was out earlier this week, so I will reach out and see if maybe there was a miscommunication. I'll see if I can get him on Zoom here shortly. Mr. Jones, Dennis Jones.
Court calls cause number CR 26-14, State versus Dennis Ray Jones. Jones is set for pretrial.
Yes, Judge. At this time, we have no contested pretrial issues. We request to be set on docket call.
All right, court will set Mr. Jones for docket call June 2nd at 9 a.m.
Thank you, Judge. Judge, next I have Mr. McPaden.
Guy Ezekiel McPaden, CR 22-36. State's motion to adjudicate. Go ahead.
Yes, Judge. Mr. McPaden is on a motion to revoke. We have an offer from the state in regards to safety. However, I've been in discussion with probation department. Mr. McPaden's been accepted to a dual diagnosis program through the VA hospital in Dallas for mental health and substance abuse. Try to get that paperwork to see if that would be an acceptable alternative to going to safety in this case.
You said if he has been accepted, that probation is supportive of that program and approves that program.
Judge, they would request to be able to review that program as well as receive progress reports from that program to make sure that is in compliance with their standards for substance abuse.
My experience with the VA is it takes forever to get anything.
Yes, Judge. My understanding with Mr. McPaden was that starting May 12th, he will be calling in to report, waiting for a bed to turn himself in to be inpatient there. And my hope is that once he's there, he'll be able to get some sort of verification or documentation to send to me. We can get that to the probation department.
He has to be on the call in for admission to get that information.
No, Judge, we've requested it now, and I will try to get it between now and then. But as you said, sometimes it takes a long time. So my hope is that if he gets a bed, gets in, that he can send it once he's there, once he gets with his caseworker inpatient.
Problem is if he does that and probation doesn't agree to it, then he's going to be taking up a bed that someone else could be using. I don't think it'd be wise for them to re-admit into a program that hasn't been approved by the state and probation department. Is that what you're telling me?
Judge, in my history of dealing with substance abuse and mental health, it seems that in the past, the VA standards have lined up with what we would require, the minimum we require here at the court's probation department. However, if you'd like for me to do some more in-depth research as to the particular program he's going to provide that to the probation department, we can do that in anticipation of him being waiting in line for that program.
I just don't want to having pre-admit into a program that the probation department and state says is not in alignment with the safety program.
Judge, he's already in line for that. He was going through some difficult time recently and actually called the suicide hotline, and they put him in line for that program. So it's
I'm telling him, he can't go to that. And he can go to that, but if he misses a court date and they say that program is not going to meet the needs that he has
yes, Judge.
with substance abuse, then he's going to be pulled out of that, the court order, and it's going to have wasted his time, and it's going to have wasted a bed potentially that someone else take advantage of. So,
And Judge,
we can't just get the documentation and the program parameters online or consultation with a caseworker.
Judge, I learned of this information from my client today. He received the information earlier this week. We called the contact that he had at the VA. My client went through several layers, but that individual was not available today. But he has left a voicemail with my email address and contact information. Additionally, Judge, I am going to follow up and be able to provide the state with that. And when I spoke to the probation department, they were willing to continue Mr. McPaden for one more setting for us to get that confirmation from him.
Right. Any objections from the state? If the court sets this on the next evidentiary docket or contested docket, which is May 28th, and if we have the information that the state needs to evaluate the program, that we set it for him to plea that day, and if we don't have it, then we either accepts the agreement or we have a contested hearing on the 28th. So it gives us 30 days to him to get that information. If he doesn't get it, then he can either accept safety or we can have a contested hearing.
Judge, I think that's fair.
Okay. Any objections from state?
No objection, Your Honor. Thank you.
Thank you, Mr. Hartwell. All right, court says Mr. McPaden, May 28th at 9 a.m.
Thank you, Your Honor.
Go ahead.
Judge, next ready on Mr. Joshua Morgan.
Joshua David Morgan, CR 22-279, CR 22-309. Mr. Morgan's on the state's motion to adjudicate.
Yes, Judge. Earlier this week, I believe on Tuesday, Mr. Morgan provided me proof of 76 hours that he had completed with Christian Love Ministries out of Tennessee, Texas. That was passed on to his probation officer. However, when we checked today, that hadn't been verified or confirmed. And so I provided some additional information about Christian Love Ministry to the probation department, email that to him. Would ask that upon confirmation of that he be allowed to continue his status on his motion to revoke.
Your Honor, states an agreement on continuing non-compliance.
Okay. All right, court sets Mr. Morgan then for May 30th. I'm sorry, not 30th, May 28th. For compliance. That's in each case.
Thank you, Judge. Judge, if I may have a little bit more time to speak to the state regarding Mr. Wingo's situation and also to track down Mr. Gray.
Yes, sir. And he's still not in.
Thank you, Judge.
If he pops in, I'll let you know. I'll have to stay for him. So more like,
I appreciate it.
Mr. White, ready on Mr. Ball? Stay ready. All right. Mr. Ball, on up. This is cause number CR 23-232, State of Texas versus Wesley J. Ball. We're here today on the defendant's motion to quash. Court finds that the motion to quash was filed on April 22nd, 2006. Mr. Ball is set for trial beginning next week. It's the number one case. Mr. White, your motion may proceed.
Your Honor, the basis of this motion to quash is the state filed what they referred to as a superseding indictment into this. It's been docketed where all the cause numbers on the new superseding indictments, CR 23-00232-1, CR 23-00232-2. These were filed on March 20. And on these, it's an act of a new grand jury, and it also adds an addition. They were filed into the same cause number that we're in here on, which is CR 23-00232. And based on this, I've got a couple of problems. First off, our Code of Criminal Procedure provides for adding additional counts, and I understand. But the way that this has been done via the form, I think is very objectionable in that we're adding the act of another grand jury into this particular case that had already been docketed. We had already had motions on and done, everything that we're supposed to do on it. So I don't really have an issue as to form or as to the substance as much as I do the form of it, except when we get down to when you read superseding indictment number 1, it sets forth the elements of an offense, just how it should. And then it concludes with against the peace and dignity of the state, which signifies to the reader that the indictment ends there, and then it is formally signed underneath that by the form of the grand jury. Within that, in CR 23-00232, the superseding indictment number 2, that one is actually signed by the grand jury form. So what we've got is two complete indictments by a different grand jury that been entered into the cause number of the previously filed case. And we've materially changed the prosecution now, because we've gone from a 1-count indictment to a 2-count charge. And the way that it's been done would indicate to me that it was an act, doesn't indicate to me, it was an act of a different grand jury. And then we've got 2 separate indictments. It's not a count 1, count 2 within the same indictment, because once you put the words against the peace and dignity of the state on it, that signifies the end of the indictment. And so we've got basically 2 rogue pleadings within the original cause number. And I think, the Code of Criminal Procedure, and I laid this out in my motion, it certainly, Article 21-24 sets forth the procedure by which they're supposed to do count 1s and count 2s and add additional counts. And certainly they can add paragraphs within the counts, for manner and means. But the way that this has been done through the form, I fear is going to create confusion in terms of how we go about this. I think the proper way to have done it, I'm not trying to prosecute my client, but is either to just got a different indictment from the grand jury with the new count as a separate charge and then filed to consolidate, saying that it was, same transaction. And I think the state could make an argument for that. But the way that this has been done isn't even a 2-count indictment. We basically got 2 separate indictments, one of which being the superseding indictment 1 that how I refer to it, has not even been signed by the foreman of the grand jury. And we have these requirements on indictments that, indicate, okay, it begins by, the traditional wording, and then it ends with against the peace and dignity of the state. And that signifies the end of it. We have that there, so we all know when the indictment ends and when it begins. And so we've got superseding indictment number 1 that wasn't signed by it. We've got superseding indictment 2, which is the act of a different grand jury with a different count added in. So now we've got 2 separate indictments, or maybe 3 within the same cause. And I don't see where in the law that we have, as it currently is, it provides for that sort of commingling of different acts of grand juries and additions to, the current original cause. I fear that it could very easily, because of the different cause numbers, could cause problems if we got to an appeal. Certainly could cause problems with the jury charge. And I think the court should grant the motion to quash and reinstate the original indictment and force us to trial on that.
Mr. White, do you have any case law regarding your argument on against the peace and the dignity of the state, formally ending the indictment?
I don't, Judge. I mean, the requirements are set forth within, I think, 2102. And, it says it specifically has to conclude with against the peace and dignity of the state. And I'm going to stand on that. That's the plain language and plain meaning of it. If that isn't in there, I don't think any of us would argue that if I filed a motion to quash, say that didn't have the requisites of the indictment, that any of us would argue that it's comported with the form that is required. And I think that absolutely signifies the end of the indictment. And it's because it says the indictment must conclude with that. And, and then it must be signed. And so we've got 2 different indictments that have been entered in, maybe 3, all in the same cause number. It's just confusing. I'm just gonna say this, I haven't seen one done like this. I've had indictments amended. I've had indictments, new ones entered and consolidated. I've certainly had them filed with multiple counts, but not with adding acts from another grand jury into an already current proceeding.
Thank you, Mr. White. Responsible state.
Thank you, Your Honor. May it please the court. Judge, first of all, I want to clear up the last statement made by Mr. White. We absolutely positively did not add the acts of a second grand jury to the acts of first grand jury. As an officer of the court, I will represent to the court that when the superseding indictment was presented to the grand jury in March of 2026, all evidence was represented as required anytime there is a superseding indictment, an amended or an addition of counts. When it is past the original grand jury 6-month term and you are presenting to a new grand jury, all evidence must be represented. That was done here. It was done by Assistant DA Alfredo Hernandez. I can call him to testify to that if necessary, but as an officer of the court, I will represent that all evidence was represented in March. Judge, may I ask, do you have a copy of the superseding indictment in front of you?
I do.
Okay. So I think it's important before I get into the legal argument to point out a couple of things here. First of all, the The superseding indictment has one file stamp on the front of it, filed for record March 20th, 2026. When you look at the heading there, it is clearly labeled superseding indictment, additional counts to follow. It is true that at the bottom of that first stage, the words against the peace and dignity of the state appear. However, 2102 for a complete indictment, for an indictment to be completed, also requires the signature of the foreperson. There is no signature of the foreperson on count one. Count one gives clear notice that additional counts are following. The second page of the filed superseding indictment is clearly styled superseding indictment, count two. There, the words against the peace and dignity of the state again appear, followed by the signature of the foreperson of the grand jury. Your Honor, if you look at 2102 and the contents that are required for an indictment, and I might add, these are the only 10 things that are required for an indictment. That list in 2102 defeats Mr. White's argument that these in fact are two separate indictments, because there is no signature of the foreperson of the grand jury on the first page. The indictment concludes with the signature of the foreperson of the grand jury. The Code of Criminal Procedure in 302 is clear that a defendant may be prosecuted in a single action for all offenses arising out of the same episode. The two counts in this indictment are offenses, separate offenses that arise out of the same episode. Additionally, in Vick versus State 991 Southwest 2nd 830, a Texas Court of Criminal Appeals opinion says two different means of committing the offense in the same transaction may be successively prosecuted, meaning that they may be prosecuted as separate offenses. In that particular case, Judge, the question was anal penetration versus vaginal penetration. Here it is an issue of vaginal penetration with the fingers versus vaginal penetration with the mouth. Clearly, those two acts may be prosecuted as two distinct offenses. They may be prosecuted in the same action, the same criminal action under 302. I've already referred to the fact that Code of Criminal Procedure 2102 sets out the requisites of an indictment. If you look through these two separate counts, each contains all of the requisites of the indictment, except count two contains the signature of the foreperson of the grand jury, which is requisite number 9, which concludes the indictment. Anything else listed on an indictment is surplusage, and there's a plethora of cases about that, Your Honor. There's cases where the title at the top has the wrong offense, a different offense than what is alleged in the body. The court found that is surplusage and is not necessary. The caption is not part of the indictment, Adams versus State. The caption identifies the charged offense as one different than what is actually charged. That does not constitute a defect in the charging instrument, nor does it give rise to a variance. Again, Stansbury versus State. The caption of an indictment is not part of the charging instrument. It's well settled law, Your Honor, that as we typically refer to it, anything above the line is not a part of the indictment itself, and any error, scrivener's error, even an error so great as to list a different charge, any error other than an error in the defendant's name, not having a defendant's name, does not affect the validity of the indictment. Here, Your Honor, we elected under Code of Criminal Procedure Section 2124 to join separate counts. That is a permitted method of doing it. Yes, Mr. White is correct. There are many methods that this could have been accomplished. The method that we elected to do it in was a single superseding indictment that has both of the counts. The evidence supporting both of those counts was submitted to the new grand jury. Finally, Judge, I would point out that the Stansberry case says no part of the caption constitutes no part of an indictment or information, and any error contained therein will be considered harmless surplusage unless a showing of prejudice is made. Mr. White continues to point to the -1 and -2 at the top. I think that makes it very clear that it is count 1 and count 2. But if he is confused by that, any confusion has been now straightened out, and he cannot show prejudice by the fact that there is a -1 and -2 at the top. He cannot show prejudice if, in fact, the first line of the last line of count number 1, where it says against the peace and dignity of the state, if in fact that is not necessary, he cannot show prejudice by that. Without prejudice, Judge, there is no error. This is a proper 2-count indictment for 2 different ways of committing the offense of sexual assault arising out of the same criminal episode.
Thank you, Ms. Curry. Final word, Mr. White.
Just real quick, just so you know, my argument such that led you to believe that I was saying y'all didn't represent it to the grand jury. That wasn't what I was saying.
Thank you.
What I'm saying is it's the act of a completely different grand jury, and now we have taken that and inserted it into this cause of action that we're here on. It's the act of a completely different grand jury, and it widens the scope of the case, changes it materially. I have no question under the law that you can do count 1, count 2. I just don't believe that you can take the act of another grand jury and put it in to a cause of action that's already been pending. This is a new cause of action. I point the court, to a case that I handled in here on appeal, trial Flynn Ship. And the state indicted the case as capital murder. It got re-indicted under a different cause number as capital murder. And then it was pled to as a murder under yet a different cause number, because the pleadings were changed. And they were the acts of it. The actual plea was a waiver of indictment and information. And what I'm saying about that is what happened on that case, and this is one of the things that I'm concerned with, is when that case went over to the 12th court originally, the motions weren't transferred over. There was confusion. And Mr. Ship had reserved his right to appeal. The case was argued before the 12th court. The 12th court originally found that there was no motion to suppress, and they denied the appeal. Mr. Ship filed an 1107. I was appointed on it. I wrote the brief. And what I'm concerned with is we got the act of a different grand jury in this particular case. And given the fact that I know the courts sometimes get real particular about how things are, I think, whether or not, I don't think that this is proper. I mean, when the different grand jury does something, we docket it, we put it in a different cause of action. If they'd amended this, sure. But this was an act of an entirely different grand jury, and we're just putting it into this cause number. And I just don't feel that that's the proper way to do this. I've only seen this done one other time, and it was in a case I handled over in Kaufman County in front of the 86th Judicial District Court, State of Texas versus Stephen Good. And in that case, the state re-indicted the case under the same cause number and added a gang enhancement. I did not handle the appeal on that. And in an unpublished opinion by the Dallas court, it's been a while since I've read it, but there's some dicta. The attorney who handled the appeal did not write on that, but the court said that it noted that I filed a motion to quash on that, with alleging basically the same thing. You can't take the acts of another grand jury and put them into the cause of what another grand jury had done. And that's what we're doing here. And I don't think the form's proper.
Thank you, Mr. White.
Judge, if I could respond to one part of that. The ship case was before my time, but that is exactly the problem. That is exactly one of the reasons we elected to do it this way. So there wouldn't be a problem with prior motions and prior proceedings not being included in a new cause number. That's one of the many reasons we elected to do it in the same cause number so that the record was very clear. Anything filed before still applied and would be preserved for appeal.
Thank you. All right, the court's going to take the arguments under advisement, and the court will research the case law cited by the state, review the statutes. The court will issue a written ruling on the motion. It'll probably be tomorrow, Mr. White, but I'll guarantee you this, it'll be before noon tomorrow, so both the state and the defense can react to the ruling as needed. Yes, sir.
Hey, Judge, I've got something.
Sir.
I got something very important. I'm on the jury panel.
Yeah, that's right.
Well, let's see, that'd be interesting. I don't know if.
So,
We'll give
I
you,
mean, I'm not gonna strike myself.
I guess you'll just have to move back and forth pretty quick. As you talk and run over there, listen and go back and talk, so.
I haven't.
That might be a first. I don't know that I've ever heard an attorney be called for jury duty on the very case that they're working in.
This is the second time it's happened.
On the second time?
I've also had it happen several times with clients that one of the first cases I ever tried in this court, my client was on.
Interesting. Mr. Thorson, that's happened to you as well?
Yes, sir.
Did you, sir, which one did you do? Did you file a motion for continuance for your jury duty service?
I was excused. I was excused.
I think
I had children under 12. There was a suggestion that I take.
Yeah.
And I've also been called for grand jury.
That'd be a good ground for a motion for continuance, you know. But your civic duty for the county that you live.
It was a
All right.
business decision from the grand jury. Too many conflicts.
I bet. All right, Mr. Ball, thank you. We'll see you Monday. Wingo, come on up. Court call CR 24-67, State versus Wayne Allen Wingo, State's motion to adjudicate. Any announcements from the defense?
Yes, Judge, Mr. Wingo, has been, and I have been in conversation with the state regarding, treatment options for his situation. Mr. Wingo, I was not clear, at our last sitting, and I told him to come up with some options, and he came up with some options that are out of state, and I explained to him that, because of his probation being here in the state of Texas and the court's, orders to remain in state, he would be unable to attend those options. And so he is currently looking for in-state options for inpatient treatment that his insurance would cover. I explained to him that if he's unable to locate an option by the next sitting, then we would be forced to either, as we did with Mr. McPaden, either have a contested hearing on the motion to revoke or adjudicate, or to accept the offer that's being extended to the state. We would request additional setting to May 28th for him to locate an option or make a decision on the state's offer.
What's the state's offer?
Your Honor, I believe it's amend to include safety, basically.
Any objections from state?
No objection, Your Honor.
All right, court will reset Mr. Wingo to May 28th. On that day, he'll either accept the state's agreement or have a contested hearing, or it'll be another agreement to another location.
Thank you, Judge. Judge, on Mr. Gray, as I said before, he had contacted our office while I was out at a conference. I received the information about his hospitalization from Mr. Schmidt. That had been forwarded on to the probation department. It does appear that he is in hospital, and so we requested his case be reset. And we'll continue to attempt to track him down and get the status for the court.
You think he's still hospitalized?
It appears that way from the messages that I got forwarded to me this morning.
No, I think Mr. Gray's hospitalized. He's not.
Oh, he's not?
Not. Conversation today. Immobile. That's what we were gonna do soon.
Judge, it appears that what I was sent on April 27th confirms that he is immobile. But I'm unable to see that he was released. All the photos I have were of him in hospital.
See if you can get in contact with him and see if he can appear via Zoom before the end of the day today.
Yes, Judge. I have emailed him and reached out to some of his family members. I'll continue doing that from my office.
Court's fine with accommodating him to appear via Zoom, but like to at least see him.
Yes, Judge.
Or we'll recall the sentence.
He's talking with him. That one.
Court call CR 22-343 State versus Martavius. Wilson, Mr. Wilson's here on the state's motion to adjudicate.
That's correct, Judge. We're gonna ask for another setting on Mr. Wilson. There's a few things I need to talk to him about. We've received an offer from the state, which I relayed this morning. I'd like an additional setting.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Wilson to May 28th. On that day, he'll either enter into an agreement or we'll have a contested hearing.
Sure. Mr. Wilson, free to go.
There you go.
So.
Mr. Thorson, go. What? No, I was talking to Mr. Thorson. All right, court calls cause number CR 22-121, State of Texas versus Andrea Nicole Young on the state's motion to adjudicate. Court previously announced on the record that Ms. Young filed a motion for continuance that was granted by the court. Case was then set for May 12th as an appearance and plea deadline date. If no agreement was reached on that date, then the court set for contested hearing on May 28th. The court ordered Ms. Young to make an appearance today to sign her notice of reset and also for drug testing by the court through the pretrial release officer. Is there any announcement from the state at this time?
Judge, could we approach what orders fine without Zoom?
Yes. All right, Ms. Young, the court has found your bail to be insufficient in this case due to your violations of your conditions of pretrial release, for testing positive for amphetamine, THC, benzodiazepines. Court hereby revokes your bail, and the court will set new bail, and you're going to be ordered taken into custody at this time. I'm gonna make that decision right now, but I need to look at the case real quick. Bail is going to be 100,000, Mr. Person. Yes, she's currently out on 50,000, so I double it. Record cause number CR 19175, State versus Cody Allen Gray. We're going to recall that case this afternoon. Mr. Manning's announced he's going to try to get Mr. Gray on Zoom, so we'll carry that case this afternoon. I believe that concludes the court's morning docket. Will resume. So 1:30 here in the courtroom with the afternoon. I believe we have several pleas. I think, right? Yes. Right, court is in recess till 1:30.